Any mention?
Please, Your Lordship.
Yes.
Your Lordship, I beg to mention item number 9, Your Lordship.
Yes.
I pray if Your Lordship can take this matter up after 2 weeks, Your Lordship.
You are paying for the petitioner.
Yes, Your Lordship.
What is the matter about?
It's regarding parity of pay, Your Lordship.
Service matter.
Yes, Your Lordship.
No objections, Your Lordship. I'm for the state.
Verse 19. At the request of the Honourable Counsel for the petitioner, list after. When?
After 2 weeks, Your Lordship.
List after 2 weeks. Yes.
Obliged, Your Lordship.
May it please, Your Lordship. Lordship, I beg to make a mention of item number 12, Your Lordship.
Well, yes.
Lordship, I pray if this matter may be taken up after 2 weeks, Your Lordship, as the learned DHI is not keeping well, Your Lordship.
No objection. He's not keeping well.
No, Your Lordship.
He's here or?
He has reached yesterday, Your Lordship, due to his health issues, Lordship.
Okay. Yes, sir. A request has been made on Mr. N. Mojika, Learned DSGI, to adjourn the matter by 2 weeks. The Land Council for the petitioner has no objection. Accordingly, list this matter after 2 weeks.
Much obliged, Lordship.
Yes.
My lord, I beg to mention item number 15, my lord. Did it come up after a week, my lord?
Who is the other side?
Mr. Guru is in the other side.
No objection, Your Lordship.
How do you know no objection? 15 also at the request of the petitioner, list after 2 weeks. 2 weeks?
After a week, my lord.
After you will take up the after a week
My lord,
matter.
my lord.
After 1 week.
Obliged, Your Lordship.
Yes. Yes, call.
May I please, Your Lordship? I beg to mention item number 14, Your Lordship.
Yes.
The conducting counsel is out of station, so I humbly pray that this matter to come up next week, Your Lordship.
With the state is the petitioner, Your Lordship, here.
Okay, this also after a week at the request of the Learned Council for the respondents. Yes.
Highly obliged.
Obliged, Your Lordship.
Supplementary cause list, item number 1.
Please, Your Lordship, I'm supposed to file an affidavit to bring and record the compromise. So
Yes.
that I've already done, Your Lordship.
You have done it.
Yes, Your Lordship.
Who is
The
paying
other
for the
side
state?
is Madam Yangi.
Yes, Mr. Khan. No one is there for the state. Now it becomes quite common. You see, the matter goes unrepresented.
This
If
is,
that be the thing, then
Apology, Your Lordship, please.
please.
It's fixed.
6 for under motion.
Yes. So we'll issue notice. You take instruction.
Apology.
Okay. Hard Learned Council for the petitioner. Issue notice. Return over in 3 weeks. The state respondent is represented by Mr. So and so. The state to take instruction. List this matter of state to take instruction. Take to take necessary instruction. List this matter after
1 week.
Yes.
Apology.
Item number 2.
Oh, wait, just a minute. Just before that, you say as per the last order of this court, the petitioner has filed an affidavit bringing into record the compromise deed dated
This was which number?
11/9/2023. Give a full stop. Then therefore is a hard land counsel petitioner. Okay.
Lordship,
Sorry.
come after a week, Lordship. Week will do.
They'll have to take instruction, isn't it? So that is what.
2 weeks. 1 week.
You just make it 2 weeks. The mix of this make it 3 weeks.
That's
Returnable in 2 weeks, list after 2 weeks also. Okay?
Lordship.
Yes.
Item number 2.
May it please your lordship. Lordship, I beg an apology, your lordship, but I pray your lordship if this matter may be taken up after a week, your lordship, as the learned DHI is on.
My lord, this is a motion matter, my lord. If your lordship kindly hears this matter and issue notice, until then they can file their reply also, my lord.
Reply is needed in criminal petition, may not be needed. It
Yes.
depends upon. Filing of reply is not compulsory. What is your case? Just tell us.
My lord, the petitioner is challenging the order dated 18/07/2024, my lord.
Where is that order?
The order is at annexure E, page 19, my lord.
This is an NDPS matter.
Yes, my lord. May I be allowed to read, my lord?
Yes, you can do it. Read.
Seen the application filed by the accused Sri so-and-so under section 167 subclause 2 CRPC for grant of bail. The application is moved by so-and-so. This application has been filed for the grant of bail to the accused person on the ground that the prosecution has failed to file the charge sheet within the mandatory period of 180 days. Shri so-and-so learned counsel appearing for DRI under the instruction of so-and-so submits that in view of the court having extended the period of investigation for another 45 days, the grant of bail to the accused on the ground of IO having failed to file the charge sheet within 180 days does not arise. I agree with the submission of the learned counsel for DRI. This court having extended the period of the investigation for another 45 days and thereby allowed further remand of the accused beyond the period of 180 days, the grant of default bail to the accused does not accrue. Hence, this bail application is disposed of, rejected and disposed of, my lord.
What is wrong?
My lord, the sole legal question which involves in this petition, my lord, is whether the learned trial court can dismiss my default bail application on the ground that since the remand petition already extended by 45 days, the default bail is not maintainable, my lord. That is the legal
What's
question.
wrong in it?
My lord,
If remand is after beyond that period of 180 days, if it is expended, that's okay.
my lord, I may be allowed to state few facts, my lord. My lord,
You state as the law. Say as the law. Fact means like you want to say that the fact that the 45 days extension was given
Yes,
is
my
not
lord.
correct. Was it given?
my lord,
Your order is dated 18/7/2023. Now you have come here. Why you go and file a bail application there? Even if go by that 45 days period that has been over long back.
but my lord, I have come here by 482, my lord. The inherent power, my lord,
There
there
has
is
to be
no,
cause for coming.
there is
has
no,
to be cause for
there is no limitation period, my lord, in 482, my lord. Kindly hear me, my lord.
You give us the law.
Yes, my lord, there is a judgment, my lord.
Yes. We are not shutting you down. We will definitely hear you. This court is interested to know, in the event of extension of time, whether that still that the question of grant of deferment is yes. What will be the relevant part?
My lord, come to page page 50, my lord, para 76, my lord. 1, 2, 3, 4, 5, 6, 7, 8, 9. My lord, line number 13, the application seeking for extension of time was very much pending. The additional session judge could not have been allowed such application promptly, that is, on or before the 90th day without giving notice to the accused. The law is now settled in view of the decision of this court in the case of Jigar alias Jimmy, Pravin Chandra Aditya versus State of Gujarat, reported in 2022 SCC Online SC 1290 that an opportunity of being heard to be given to an accused before the time is extended up to 180 days to complete the investigation. The error or lapse on the part of the appellant Jasbir and Ranveer Singh was that they failed to prefer an appropriate application seeking statutory default bail on the 91st day. If as much the application would have been filed, the court would have no option but release them on statutory bail. The court could have said that since the extension application was pending, it shall pass an appropriate order only after extension application was decided. That again would have been sometimes contrary to well settled.
We understand. When your bail application was filed?
My lord, I have filed my bail application on the 180 days. I was remanded on 14.
What was that date?
I was remanded on 14/01/2023, my lord, the day of my remand.
When that 180 days expired, according to you?
The day of expired, it expired on the 13th, my lord, on the 13th July 2023, my lord.
When did you file your bail application?
I filed my bail application, my lord, on the 14th of July 2023.
When this application for extension was considered?
The application for extension was considered on 18 July, my lord. 18 July 2023, wherein the learned trial court has.
18 July court has. Where is that order by which the time was extended? 45 days.
My lord, for 18/07/2023 was the order wherein my bail application was rejected.
Where is that order of extension?
The order of
45 days.
Order of extension is. Order of extension is on
Where is that order? At which page?
18/07/2023 at page Annexure A, my lord.
Annexure A.
A, yes, my lord. Having heard the learned counsel and on perusal of the record, the counsel for DRI, this court is of the view that considering the nature of the offence involving commercial quantity, this court is satisfied to allow the prayer for extension of the period of investigation for another 45 days and allow further remand of the accused person beyond the period of 180 days. The extension of time for investigation shall count on 13/07/2023.
When was that filed?
The bail application was filed on 14/07, my lord. Annexure C, my lord. This is the CR put up today, seen the application filed by the accused so and so under section 167 subclause 2 CRPC for grant of bail.
Yes.
The application, the matter is listed on 18/07/2000.
Now the thing is that. Thing is that.
Yes, my lord.
Thing is that you are challenging an order passed on 23/7.
18/07/2023, my lord. Both the applications of extension of time.
All right, 18/7.
Yes, my lord.
Now, whatever the case is.
Yes, my lord.
Even if the trial court had committed an error.
Yes, my lord.
That period has gone. You go and approach the trial court again. The rejection was on the ground, or rather we can say under a misconceived notion of extension of 45 days. Now you say that your bail application was filed prior to the extension of 45 days. Then in such a case you are entitled to get deferred bail, isn't it?
Yes, my lord.
Now it seems that it has been rejected by the court below, saying that since there is an extension of 45 days, you are not entitled to deferred bail.
Yes, my lord.
But now the situation has changed.
But my lord.
Why you do want this? If you wanted to challenge this order,
my lord,
you should have challenged it then.
My lord, the the both things are different, my lord. The jurisdiction of extension of period and the jurisdiction of default bail, my lord, has two different things, my lord. Default bail is my statutory right, my lord, and extension of period is the prosecution has not filed the charge sheet on the required date, my lord. Here, what the learned trial court has done is, my lord, had both the applications, my lord, had deferred it to 1807-2023 to decide my bail application when my right has already accrued, my lord. And my lord, in this judgment, my lord, the learned Honorable Supreme Court has clearly stated that, my lord, that at that time, my lord, while deciding the default bail application, the learned trial court cannot say that first it will decide the extension period, then
That is what the
that my right will be.
That is what the law you have placed before the court.
Yes,
We
my lord.
understand that.
Yes, my lord.
We understand that. Now the fact remains that your entire plea for grant of bail is based on the expiry of that period of time. That means default bail. You want advantage of default bail. Now, say let us assume that the court had rejected it wrongly.
Yes, my lord.
Okay. But then this order was passed last year.
My
the
lord,
court had rejected because because under a misconception that the 45 days was extended. Okay, that was the misconception. Now that 45 days also is over. So you go raise your plea, because see, this rejection, if it is done under the wrong notion, that also cannot be corrected now, because you have come after that 45 days now.
my lord,
Even if you go by the interpretation of the trial court's order, then also you are entitled to default bail. Why you are not going there?
my lord, I have gone there, my lord. My bail has been rejected, so I'm here to quash the order.
See, quashing
The order of dated 1807-2023, my lord. That's my prayer, my lord, because
which way this quashing will help you? Your purpose is to get the
to set aside the order, my lord, dated 1807-2023.
let them reply. Yes, madam, we are issuing notice. You accept the notice.
Okay, Lordship.
File your response. You have a point. This court is not saying not, but then why you are late in approaching? It appears that yes, your case has merit. But then, even if we say that the 45 period, the trial court has misconstrued it, but now that 45 days period is over.
But my
So
lord, that
your
45.
entitlement- Now, what is it? Is it a kind of moral victory for you? Then
No, my lord. My lord, that 45 days was granted in favor of the prosecution in order to complete the investigation.
That 45 days is over. Your rejection of your prayer of bail before the trial court is because of the extension of 45 days, which you say that is been done wrongly.
My lord, it has been done wrongly because, my lord.
We understand. Now that 45 days is gone. Now the wrong, the benefit of wrong has gone to the prosecution already. Now question remains that about the correctness of that order. We say it is wrong.
Yes, my lord.
Then if it is wrong also, can you get back the 45 days? You do not understand that is the thing. Even if you go by the wrong interpretation of the court below, then 45 days is over from 18/7 by now. So that makes you entitled to file another application before the court for the same relief for which you are coming here. Now your contention is that you want that order to get set aside.
Yes, my lord.
What if you set aside also, what extra relief you get? It's a kind of moral victory, nothing else.
Yes, my lord. Let the order be set
So
aside.
you want that moral victory. That is what you said that right from the beginning. The court was trying to say that. Otherwise, your entitlement, if at all your contention is correct for default bail, if it is there before this court, if it is now available before that court, even in spite of passing of that wrong order, for the relief which you may get it there, you have come here. Anyway, hard. So and so, issue notice. You have a case. You are not having. You have raised good ground. Your point which you have raised, that is correct. But then the delay defeats equity. Hard. So and so. It is 482 application, isn't it? Issue notice. Then you say, Miss so and so appears. Accept notice on behalf of so and so. There is only this one respondent. How many respondents are there?
Only one respondent, my lord.
Only one respondent. This is matter after 2 weeks. The respondent shall have instruction by that time. Okay. Yes.
Highly obliged, Lord.
Item number 3.
Yes.
You just said.
But it's fixed for instructions.
Yes.
After notice instructions.
Lordship, we have received, we have sent it to the department, but we have not received specific instruction. But I've gone through the petition, and Lordship, there are sufficient materials. Maybe he can start the hearing because the department is slightly reluctant, saying that everything was done based on the full bench decision.
Reluctant means what reluctant? Then if that be the thing that you said, that is your instruction.
No, there are not an instruction. They're still getting the copy because the FIR was filed on the basis of seize cold.
No. The last occasion this court has passed this order, allowing you to take instruction.
Lordship, yes.
So
we
what
have-
you say, you need instruction or you will proceed without instruction?
Lordship will proceed with it.
What is the case about? Sir?
Then in that case, my lord, let it be fixed for hearing. We'll do a full-fledged hearing.
Okay. It has been submitted by Mr. K. Khandane AG that no instruction has been received by him. He, however, submits that department's instruction may not be very much necessary for the purpose of adjudication of this matter. Stop. In view of the submission, the Learned Counsel for the in view of the submission of the state, the Learned Counsel for the petitioners says that matter can be fixed for hearing. Matter is
Final hearing.
accordingly this is matter for hearing after 2 weeks.
Deeply obliged.
Item number 4.
My lord, the connected matter is coming up tomorrow, my lord. WPC 164 of 2024, my lord. So let it come along with that other matter.
What is connected matter?
It's WPC 164 of
It is pertaining the same thing.
my
Same
lord.
parties. I'm mattering appearance today for respondent number 5, my lord.
And then what do you say?
On my
What is
behalf,
your
I submitted
submission?
2 weeks time may be given. I'll file my affidavit.
They'll have to file an affidavit if we
There is
take
an
it up
interim
tomorrow.
pair in this matter, my lord.
Yeah?
There is an interim pair in this matter, my lord. So, my
No,
lord,
but
I'm
then
saying this matter will
nothing
be
is
taken
said
up
about
tomorrow.
this thing. Anyway, the land we will have it. Here for the state. Yes. Anyway, it is the Land Council for the petitioner submits that this matter may get taken up. Another connected matter, which is coming up tomorrow. In view of the submission, this is matter tomorrow. Give, within bracket, you just give it. Okay. We'll just see tomorrow.
My lord. Obliged.
Obliged, Lordship.
Hearing item number 5.
May please, Your Lordship.
Yes.
Lordship, this is that Nakma matter, Your Lordship, where petitioner number 1 passed away, Your Lordship. However, time and again, we have taken time to bring on record the death of the petitioner, Your Lordship.
Yes.
On the last occasion, Your Lordship, we just made contact to the. On the last occasion, Your Lordship, we just made contact to the client. However, Your Lordship, they said they will send the documents, Lordship, but we are still awaiting, Your Lordship. So I'm praying for 3 days time, Your
Things
Lordship.
will remain like this.
3 days time may be granted, Your Lordship.
No objection, Your Lordship.
She is ready to help you. Okay, on the prayer made by so and so Learned Council appearing for the petitioner. Further, how long?
1 week, Your Lordship.
1 week's time is granted. On the prayer so and so, why is not come to the petitioner? Okay, further 1 week time is granted for filing an application for striking out the name of the petitioner number 1 in the matter. List accordingly.
Item number 6.
My lord, on the last occasion, my lord has asked me to inquire about his initial entry into the service. So, my lord, his initial entry was in the year 1998 for a period of 1 year under 3F.
See, this matter was heard quite some time back. You have to refresh the court about.
My lord, if I can pray, let this matter come up some other time because Mr. KP is handling this case. So.
Where is he?
He's unavailable, my lord.
He's on his legs before other court. He's not here.
Not here.
He's absent today.
I didn't see him.
So you are standing up without any instruction?
No, one of my colleagues, she told me to appear.
No, what is your instruction then?
Just
you are standing up to say what?
That to list of matters for after 2 weeks.
Well.
Anyway, this is a problem, Mr. Sinkan. When there is a gap, the court forgets.
My lord, again we have to restart.
And even if these orders are passed that you need some instruction and all, then you see by the time when it comes up next, this court will forget. Just say on the request made. You're there, Mr. Hajarika?
No.
KP, my lord, KP is absent.
Yes.
So, okay.
And the request made on behalf of the state respondents, list this matter after 2 weeks.
Obliged.
Item number 7.
You make it at the request.
This is the matter, Your Lordship. Last occasion, I was requested to what's the instruction of
Nobody
my.
appeared for the petitioner. Last occasion also nobody appeared. Who appears for the petitioner here?
Mr. Arja.
We'll dismiss the matter. This default in consecutively. None appears for the petitioner. Yes, you are there, madam? For?
Sir, with me.
Okay, with you. None appears for the petitioner. Stop. Mr. R. Definite. Learned CGC is present on behalf of the respondents. You appear for all the respondents.
Yes, sir.
Yes. On the last occasion, also, no one appeared on behalf of the petitioner. Stop. It seems the petitioner has lost interest. Petitioner has no interest to pursue the matter. Accordingly, the matter stands dismissed for non-prosecution. Yes.
Item number 8.
Earlier, Lordship remember, I think KP what I said, it took time. Several days time was taken, I think right from 2019 is going on.
What is to be done today? If he is not there, we cannot decide on merit. And for one default, we do not want to decide.
No, obviously.
So, what do you suggest? We'll just have it on some other day.
Your Lordship, please. Because I feel bad also.
That will not be a problem for you, isn't it?
No, it's all right.
None appears for the petitioner. Mr. SP Mohanta, along with so and so, is present for respond number 1, 2, and 3. When shall we have it?
Any day I'm.
Give para and just list this matter after 2 weeks.
2 weeks or after 1 week also, I think it's okay because this is a small matter. In fact, disputed question of facts.
List this matter after 1 week. Okay, is that all right?
Item number 10.
Watch.
This matter where provision appeal is there. Now you have a judgment against you in 2024 passed by Supreme Court. So be that is what you do. You see, this court will not entertain. And what is your instruction today?
Lordship,
Ready for argument?
No, Lordship, to that extent, Lordship, whether to appeal, we are seeking instruction, Your Lordship. To that extent, whether we'll go for appeal or proceed here, Lordship, we are seeking instruction, Your Lordship.
But after
See,
2020.
you have to go. You see, this is a case of 2020, isn't it? I think there is a period prescribed for under Limitation Act for preparing appeal, or maybe in the Act.
And in the Act it is not there, but
the Limitation Act
Act will
applies. Provision of Limitation Act is applicable.
applicable.
So that when the condemnation also will come.
Condemnation also.
So if you are ready, we can dispose it. I will direct you to file an appeal, and we will say that the period spent here may be excluded.
Lordship, senior counsel will be in better position to assess this honorable
If you are not ready, next day we will dismiss your case and we will not give any liberty also.
Lordship. 1
Yes.
week, Your Lordship.
When do you want it?
1 week, Your Lordship.
Yes, madam.
Okay, Lordship.
This will go on like this. Small
Lordship.
matters.
My apology, Your Lordship.
Just look for yourself now. Even Apex Court also has the same view. So when there is alternative remedy, normally it should not be entered. It is only in some certain situations. So we'll have it after a week. Say at the request made on behalf of the petitioner, this is matter after a week.
Highly obliged, Lordship.
Item number 11.
Lordship, here the matter was heard at length on the previous occasion by Mr. A. Khan. Now, as per the last order, Lordship, they are supposed to bring some instruction, Lordship, today.
What are those instructions? That's
Yeah, 38.
What are the instruction in relation to? Let us say, this for some time this matter was pending before the Honorable Chief Justice also.
Yeah, I think once or twice.
Any effective order passed by that court?
No, my lord. No order has been passed.
What for this instruction was needed, madam?
In respect of his approval, my lord, from the government.
Termination.
These are again school appointment.
Yes,
clauses.
Lordship.
See, your instruction was okay. Now that is for the petitioner. See, there is some order passed on 9/19/2, and it says petitioner submits that he would require some more time, some more instruction from the petitioner, especially with regard to whether the petitioner is still interested in pursuing the case or not. So that is what the instruction you were.
Yeah, after that matter was heard, Lordship. After the matter was heard, Lordship. After the subsequent the matter was placed before
After that, this matter went before the
Yes, Lordship.
Chief Justice.
Chief Justice. And again the matter was placed before this honorable court on the last occasion, 38th of May, Lordship. The matter was substantially heard from all the parties. Then let them to have the instruction, Lordship.
You are there for the state.
For the
Yes,
state,
please.
Lordship.
This you will have to refresh this court. The problem
That's
is
why.
that
Let them to have the instruction after that. Mr. Khan will.
Lord Counsel appearing for the respondent number 7 and 9. Praise for grant of some more time. The prayer has not been opposed by the counsel by the petitioner. Prayer allowed. List after 2 weeks. Yes.
30.